If you look at your syllabus, uh, there are few points in syllabus pertaining to this aspect. So privileges and issues arising out of it. असं काहीतरी तुमच्या सिलेबस मध्ये लिहिलेलं असं बोलतो. माहिती आहे का तुम्हाला असं काही वाचलाय सिलेबस मध्ये तुम्ही? अच्छा बोल. So we will start with discussion of privileges. There are few issues which I think in coming years you may come across in mails. So far as legislature is concerned, in previous lecture we talked about qualifications and disqualifications. Disqualifications being more particular. So we have discussed the constitutional disqualifications and statutory disqualifications. Those statutory disqualifications we have partially discussed it. We can still have a little bit more discussion on Representation of People's Act 1951, and there are few more details or few issues arising out of that act which we can still discuss. Let's see, we'll arrange that lecture also in coming time. But till then, the next point in legislature is privileges, and we will talk about this probably today and tomorrow. I don't think that we'll be able to complete in 2 lectures. Let's see how it goes. Once we are done with this, we will start with judiciary. Right? Again, in judiciary, there are specific topics which I will discuss at length. Some other topics I will definitely talk about, but not at length. जैसे जो लक्ष्मीकांत ने दिया हुआ है पावर्स कौन से तो हम लोग डिस्कस करेंगे पहले लेक्चर में. But then judicial review, adventurism, judicial activism, overreach. For this part, we will dedicate more time. We will dedicate time more for reforms in judiciary and collegium system, and also to NJSC, right? Judicial independence and judicial transparency. So these are the points which we are going to target in our lecture. Clear? Everyone? Right. So let us begin with privileges and processes. Basically, so far as parliamentary privileges are concerned or legislative privileges are concerned, these privileges are considered as sort of a shield used by legislative assemblies to protect themselves against any external influence. So looking at these privileges from that perspective, again brings us back to the idea of separation of powers. So as we talked about office of profit, if you remember, while discussing office of profit, we linked it with separation of powers. Am I correct? While discussing other disqualifications also, we tried to link it with idea of separation of powers. We did independently discuss those things, but then we linked it with separation of powers. In similar manner, when we are talking about privileges independently we will discuss them, but we will simultaneously link them with the issues pertaining to separation of powers or separation of authority. So let us see what these privileges are and when exactly have they been brought into force. If we look at privileges, whether of parliament or state legislature, these privileges have been provided in the constitution as a check to be exercised by legislature over the members sitting in the legislature, as well as any external person or entity. So here we are going to look at it from 2 perspectives. One, these checks as a tool to control members sitting inside the legislature. And second, these privileges as a tool to control the activities of members, those who are not part of legislature, but they are outside the legislature. Are you getting it? Right? And what would be their impact on the behavior or maybe activities of members of legislature? So as your judiciary tries to protect itself from an intrusion of executive as well as legislature, so is the case with the legislature. Legislature would try and protect itself from an intrusion from at least outside members, right? So it won't entertain any intrusion or any interference by court, and it is also not in a mood to entertain any influence from executives. But to this extent, it is fine. It is easy to understand. Of course, not that easy, but then we can understand, okay, fine, it is debate between legislature, judiciary, and executive. Most important issues which have came up after independence, and not just in India, but abroad also, they come from the fact that legislature is threatened, or the legislative members are threatened, or they perceive a threat from outside the legislature, which is not necessarily, in fact, it is not an incident threat, but a threat from an individual, a common man. So common man speaks, a common man exercises his or her right under 19 clause 1A, freedom of speech and expression, makes a comment or expression which is considered to be violative of dignity of legislature. And so legislature finds it to be, or finds it or considers it as its contempt. And we have got a number of such cases in India wherein the debate again and again came in front of the court whether the dissent, if it is to be called as a dissent, a legitimate dissent of an individual that is a citizen, to be given a priority, or the protection of rights of legislators to be given a priority. Court in most of the cases have favored the position of legislature. And yes, of course, at times, court has also tried to protect the fundamental rights of citizens also against the arbitrariness practiced by legislature. Legislature, you will find that will control and suffocate you if you try to speak something against it. And legislature, being a constitutional agency, has that power under constitution to punish you for its contempt, as is the case with the court. You all must be aware about contempt of court. At least you must have heard about it. So if somebody is found to be guilty of contempt of court, the person would be punished by the judiciary itself. In similar way, there is something called as contempt of legislature. And if somebody is found to be or perceived to be committing that contempt, then legislature would take an action against him or her. And here lies the interesting story. The reason being, almost every matter that has come in front of the court comes because the legislature has arbitrarily tried to control the fundamental right under Article 19(1)(a), so far as Indian jurisdiction is concerned. If we look at the exercise of these privileges and use of these privileges by members of legislatures in other jurisdictions, you'll find the story is little different. Thoda sa alag hai. So we are going to talk about these two things. One, we are going to talk about legislature vis-a-vis or versus your judiciary and executive. And second major aspect that we are going to cover is legislature versus a citizen. Is it clear? So all issues we are going to discuss would fall basically into these two domains. Right? After understanding this, as we have talked about anti-defection law, I would request you to link anti-defection law with this particular debate which we are going to have, and then understand the effect of anti-defection law and on individual members sitting in the house, and then try to understand whether the law must prevail or individual member sitting in the house, his right under constitution must prevail. Right? There is that debate also, which we will see if we can manage to club it together while discussing itself. Right? दोन गोष्टी समजल्या तुम्हाला मी काय सांगितलं. we are going to look at this from two perspectives. One, institutional debate, and second, institution versus citizen. Okay? Good. So let us begin then. So introduction. There is a rationale. What is the rationale behind legislative privileges? Is to protect lawmakers from interference by others in the discharge of their essential functions. So what is the essential function of the legislature? To make a law. Anything else? To amend the law. It is again legislative power. Okay. Anything else? See, the most important function that your your legislature, mostly in all representative democratic nation states, will find that the duty of first and prime duty of legislature is to keep control over and watch over executives. Right? It is their duty to keep check over executive. Then second is making a law. And then there are other functions also. You know? So the core rationale here is to enable them to function as an independent agency without any interference. This broadly entails their use as a shield against undue intrusion by the executive branch, the court, and the private parties. So here we are saying that this is basically a protection given to the legislature. Being more particular, it is to legislator, protection of a legislator against court, executive, and private parties. So from where have we borrowed these privileges? So we have borrowed it from England. जिनके पास अपना खुद का लिखा हुआ कुछ नहीं है, उधर से हम लोग लेके आए, ठीक है ना? तो हमने क्या लेके आया फिर? ये तो हमने भी नहीं लिखा होगा. We don't have privileges written elaborately in our constitution. Forget about elaboration. Nothing, no single individual mention of a privilege is I'm saying like you will find it in the book. In the constitution. There is nothing mentioned in the constitution. Almost all 99.99% matters pertaining to privileges are decided on the basis of conventions. They have their origin or birth in history of England, not of India. Of course, some of these privileges can be drawn back to, or you can search for some of these privileges in Government of India Act 1935. But most of the privileges, as I said, they are borrowed from practices which finally establish their role in functioning of British legislation. And we have borrowed those practices as it is in India. So if you look at, that is the reason why we have to go back to that history a little bit to understand what role did these privileges play in England. So in medieval England, they were initially started by legislators to register. They were initially started, or you can say stated by legislators to resist arrest and prosecution on account of words spoken on the floor of the House. So the members of the legislature in England, House of Commons, being more particular, rarely in case of House of Lords, but in case of House of Commons, the words spoken by them on the floor, for such words they used to be arrested and they used to be prosecuted. The matter is who used to prosecute them and what for. If they were the members of the House of Commons, if they speak something, they might be speaking about or in favor of the common man, right? Why would somebody arrest them? In fact, who you think would arrest them? Who you think would prosecute them? And what for? These words must not be pleasing someone or something or maybe some institution. That's the reason why they were being arrested or maybe prosecuted, isn't it? you have to identify the institution. It is crown. The crown in England used to find some of those features and the words used on the floor to be violative of its dignity. If not dignity, then at least its interests, maybe financial, political, or other interests. So we are basically talking about that Europe, which was very well fairly divided into those three estates, wherein the third estate hardly used to have any say in decision making and in polity. In that Europe, you will find these legislators strive very hard to establish their position at the first place. And when they used to speak while establishing their position, they used to face such a hardship. And so, as you can see in medieval England, modern की बात नहीं कर रहे हम लोग, medieval England की बात कर रहे हैं. These legislators there in medieval England started claiming their rights. As a member of the house, they started claiming their rights. They were far more aggressive and assertive. I'm saying aggressive and assertive about their rights in the house. है ना? Your medieval or our medieval India starts from Kutubuddin Aibak, है ना? Playing polo and while playing he died. नहीं का? माइकल सुना तुम्हारा? And in that time period in England, we had a cabinet, like they had a cabinet government in England. कधी आलं तुमच्याकडे कुतुबुद्दीन ऐबक 1206 1206 AD, died in 1210, है ना? 1210 त्याचा मृत्यू आहे. कोण? कुतुबुद्दीन ऐबक. बरोबर ना? पोलो खेळत होते. आपण काय करू त्यावर? हमें डेमोक्रेसी का डी भी नहीं मालूम, चलो वहां पे भी नहीं मालूम था, but they had a very well established courtroom and then system wherein debates could take place. We are talking about 11th century, 11th or 12th century. French Revolution takes place. Date, Mike, French Revolution 1789, 98, 89, 100% का 1000, 1779 क्या था? होगा कुछ सर, क्या करना? जाके देखना. चलो 1789 है ना? फर्स्ट कैबिनेट comes into फ्रांस, है ना? कौन सा साल है? इलेक्टेड गवर्नमेंट, जेरोनिस्ट कमिंग टू द पावर. अच्छा चलो लास्ट डिकेड ऑफ 17th सेंचुरी हम लोग बोलते हैं फिलहाल, है ना? इतना तो ठीक है. सॉरी 18th सेंचुरी एवढं ठीक आहे ना? काही डेटच्या मागे नका तुम्ही जेव्हा अभ्यास कराल तेव्हा. That was the time, right, when you have India being sort of invaded by foreign powers. तब तक तो हम लोग मतलब वो ट्रेडिशनल लाइफ में जी रहे, तो मॉडर्निटी इंट्रोड्यूस हो रही है ना? उस वक्त इंग्लैंड में डिबेट होता है ये प्रिविलेजेस के ऊपर, है ना? ये मैं क्यों बता रहा हूँ आपको, ये समझाने के लिए कि हमें क्यों जरूरत पड़ी, कि हमें बोरो क्यों करना पड़ा, क्यों नहीं हमने अलग से प्रिविलेजेस को खुद ही लिखा. अच्छा चलो बोरो भी किया हमने, तो हमने कॉन्स्टिट्यूशन में क्यों नहीं लिखा? एक शेड्यूल ऐड कर देते, फिर एक पार्लियामेंट आपके कॉन्स्टिट्यूशन में एक शेड्यूल ऐड कर देते, वहां पे सभी प्रिविलेजेस होते. वो नहीं लिखा हुआ. इसके पीछे इतने सालों की हिस्ट्री है, मतलब सेंचुरीज टुगेदर. प्रिविलेजेस को अगर कोडिफाई करना है तो शायद सेंचुरीज टुगेदर का हमें we had to study those privileges, their evolution, right? We had to put it them in a precise language so as to make a law or so as to make it binding as per the as per the constitution. And so we continued as it is, है ना? हमने क्या किया? ऐसे ही कंटिन्यू किया privileges as a convention. अब मैटर ये बनता है यहाँ पे, तो क्या हुआ सर ना, मतलब कन्वेंशन है तो है, फॉलो तो कर रहे हैं ना हम लोग, है ना? बात इसकी नहीं है. क्या होगा अगर कोई प्रिविलेज वायलेट होगा, और क्या होगा अगर कोई कन्वेंशन जो प्रिविलेजेस से तैयार हुआ वो कन्वेंशन आपके कॉन्स्टिट्यूशन की किसी आर्टिकल के अगेंस्ट जाता. हम लोग यहाँ पे बैठ के आसानी से बोल सकते हैं हम लोग तो कन्वेंशन को फिर सर अनकॉन्स्टिट्यूशनल डिक्लेयर करेंगे, ये कौन सी बड़ी बात है? है ना? लेकिन ऐसी बात नहीं है. That is not the case. And so you have to understand from where have these privileges came and what is their status in India under Indian Constitution and how are we practicing them. So at the first place, they come from medieval England, wherein the legislators actually asserted them to resist against that arrest and prosecution on the account of speeches and words spoken by them on the floor. They include legislative chambers powers to control publication of its proceedings. Since unauthorized publications could expose legislators to unwelcome scrutiny and hamper their performance. क्या होता है privileges में? कौन सी चीजें होती है? Basically, privileges are full of powers given to. They are nothing but powers given to the chambers, Lok Sabha and Rajya Sabha. So the powers of Lok Sabha and Rajya Sabha are practically speaking exercised by the chairpersons, those who are in the chair of Speaker and then Chairman of Rajya Sabha, right? So basically these powers are exercised by chairpersons on behalf of institution as a whole. So here we are talking about the chairperson exercising these powers to protect the members of that house, right? Now the chairpersons across India in every chamber has a power to permit the publication of things which are discussed, which are spoken, voted on, or resolutions passed and bills passed on the floor only with the permission of the speaker or only with the permission of that particular chair can you manage to publish it in public domain. Otherwise you cannot. This is ensured for the sake of to ensure that the legislatures and the members sitting in the legislature are adequately protected from any possible interference and influence to say on these members while passing a policy. For example, as this government did, they passed farm laws in the form of ordinance. If they would have kept it in the legislature, that would have definitely triggered a debate in the legislature. And that debate is definitely necessary so far as democratic functioning of your legislature is concerned. But putting that in the legislature is nothing but inviting a debate in public domain. So government wanted to bypass all these things and then simply bring in the laws. Of course, it is undemocratic, no doubt about it. But then still. So what is wrong if debate takes place in public domain? As is the case with your judiciary, any matter that is sub judice should not be discussed in the public. The reason being such discussions in public and on public platform result into undue influence on the judges while they decide the matters. In similar manner, the policy that is still in a legislature, which is not yet finalized, in a proper procedural manner, debate should take place on that policy. And there should not be sudden spike in the exchange of opinions beyond the house, or we can say out of the house in actual public domain. That can be politically exploited by opposition, to arrest the policies of the state. Probably such policies may come with really good intention. And to avoid such possibilities, you'll find that some privileges have been mentioned in the, or some privileges have been developed, or they have evolved over the period of time. So you can read in this particular paragraph, they include chambers' powers to control or to have a control over publication of the matter that is being discussed or that is to be finalized on the floor. In a framework of a representative democracy, their scope is intrinsically linked to the objective of ensuring unfettered deliberations inside the legislature, which I was explaining just a while ago. So what is their scope? Scope क्या है? Privileges का क्या scope है? जैसे fundamental rights का scope हम लोग देखते हैं. What is the scope of privileges? Or for that matter, let us make it simple. What is the scope of process of appointment of judges in the Supreme Court. The scope is basically the moment you come across this particular point, like collegium system and all, you will find that you are basically focusing on judiciary and its independence. Am I correct? So basically the scope of this appointment process is to protect judiciary. Barabar? In similar manner, the scope of these privileges is to ensure that your legislature remains protected. As you can see in this line, in the framework of representative democracy particularly, their scope is intrinsically linked to the objective of ensuring unfettered deliberations on the floor of the House. Right? This is true for Parliament, this is true for state legislature. I'll give you an example just to substantiate this point. Hardly few years ago, few bhi zyada ho jayega actually, 2 years ago, we had a government here in Maharashtra. Abhi to nahi hai wo government. There was the former Chief Minister of Maharashtra was openly criticized on one television channel. And the anchor of that particular show was held responsible for violating the dignity of the House. And against him, in fact, he was arrested also. And against him, charges were put by the Legislative Assembly of State of Maharashtra. And the matter went to the Supreme Court. I hope some of you must be knowing this. Matter went to the Supreme Court. Supreme Court issued a notice. I will come to that case later on in little bit detail. But then Supreme Court issued a notice to the Secretary of State Legislative Assembly of Maharashtra. Right? Wherein court asked the Secretary, in what manner do you think the speech and the words used by this particular fellow on a particular show, are violative of dignity of the House? He had to explain it, that is different story. Now don't look at that particular anchor as anchor of particular channel. Look at him as a citizen of India. And then look at the institution, that is legislature of state. You will understand the debate. You all know that a citizen of India under Constitution Article 19 Clause 1A has freedom to speak and express. Of course, it has reasonable restrictions, no doubt about that. And if you look at 1919 Clause 2, it clearly makes a mention of contempt of legislature as one of the points as a limitation on your and my freedom of expression. And those speeches made, or maybe that show and the way he tried to conduct that particular show, that definitely hampered the functioning of the legislature. So legislature took an action. So if you now look at this particular point, the scope of these privileges is intrinsically linked to ensure that, what is the objective of privileges? The objective is basically to ensure that the legislature functions independent of any external influence. It may be the case that influence is actually necessary, worth considering in policy making, and it may be the case that influence or those movements are actually framed just for the sake of political mileage. There are possibilities, and to avoid such influences, you'll find that privileges have been given. है ना, हम थोड़ा डिटेल जाएंगे आगे. मैं बस अभी आपको इंट्रोडक्शन दे रहा हूँ. So in India, particularly in post-independence period, their invocation has been controversial in several instances, and the open-textured nature of relevant constitutional provisions has precipitated the calls for codification. So आज की बात नहीं, कॉन्स्टिट्यूएंट असेंबली डिबेट जो है ना, कॉन्स्टिट्यूएंट असेंबली में भी बात हुई इसकी. डॉक्टर अम्बेडकर को बोला गया कि इतना बहुत जरूरी है तो क्यों ना हम लोग कोडिफाई करें इसको, लिख देते ना, जो भी प्रिविलेजेस है लिख देंगे, बात सही हो जाएगी. So the matter is, there are few provisions in the Constitution of India which are open texture. What do you mean by open texture? They can be interpreted liberally, and such a liberal interpretation of those provisions would bring you in a difficulty while interpreting the conventions established, privileges established by conventions. And so the controversy. So Indian Supreme Court's ruling in this area have aggravated the uncertainty about their relationship with fundamental rights, especially speech and personal liberty. This, I think, is an important point. In coming 1 or 2 years, you may come across questions in your mains, particularly on this particular aspect. So please be vigilant while you read your newspaper. If you come across any issue pertaining to this, बिल्कुल नोट करके रखो. ये बहुत पॉसिबल है इसके ऊपर क्वेश्चन आना. आगे चलते हैं. तो कोर्ट ने क्या किया, जैसे वो राइट टू फंडामेंटल राइट टू रिलीजन में देखा था हमने, सेक्युलरिज्म एसेंशियल टेस्ट वाला प्रैक्टिस, उसमें जो कॉम्प्लिकेशंस कोर्ट ने तैयार किए, उसी तरह से कोर्ट के रूलिंग्स हमारे लिए प्रिविलेजेस के मैटर्स में भी कॉम्प्लिकेशंस क्रिएट कर, मतलब they created complications. This prompts us to ask whether exercise of legislative privileges is justiciable, and if so, to what extent. While constitutional bench decisions have favored limited judicial scrutiny, there is a room for debate in the light of broader principles of separation of powers. Now let me explain this, and then we will move ahead. What this statement says, so we are basically asking a question. पहली बात तो हमें हमारे पास लिखा हुआ कुछ नहीं. I hope you all are with me. पता है ना तुम्हारा? हम लोग अभी भी इंट्रोडक्शन में ही है. थोड़ा प्लीज ध्यान देना. पहली बात तो हमारे पास लिखा हुआ कुछ नहीं है ना, ये कॉन्स्टिट्यूशन में लिखा नहीं. दूसरी चीज, ये हमने बोरो किया इंग्लैंड से. तीसरी चीज, हमारे यहाँ पे इंडिया में किसी भी कॉन्स्टिट्यूशनल मैटर पे कोई अगर इश्यू होता है तो आप सुप्रीम कोर्ट के पास जाते हो, है ना, और सुप्रीम कोर्ट जो भी रूलिंग देगा, जो भी जजमेंट्स होंगे, उसको हम लोग मान के चलते हैं, हाँ सही है जजमेंट्स, और वही इंटरप्रिटेशन होगा कॉन्स्टिट्यूशन. So the interpretations given or maybe judgments given by the Supreme Court have made us far more confused than resolving our issues, right? And so this makes us to ask a question whether exercise of legislative privileges is justiciable. पहली बात तो ये है कि ये justiciable है क्या? Can you really go into court and ask and get it enforced through court of law? पहला question. Are you all getting this? Everyone, आपके फंडामेंटल राइट जस्टिसेबल है कि नहीं है ना? क्यों जस्टिसेबल है? किसने बोला आपको? किसने बोला जस्टिसेबल? कॉन्स्टिट्यूशन में लिखा हुआ है भाई, वो किसी ने बोलने की जरूरत, कोर्ट ने भी बोलने की जरूरत नहीं है. कॉन्स्टिट्यूशन में लिखा हुआ है. You can go for it and you can get it established, isn't it? Everybody, right? Now something that is not written in the constitution, how sure are you that it is justiciable? If at all it is. अगर है तो कैसे मान ले हम लोग कि जस्टिसेबल? अगर नहीं तो फिर कैसे, मतलब फिर उसका कोई मतलब नहीं बनता अगर जस्टिसेबल नहीं है. डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी है तो लिखा हुआ बहुत सारा वहां पे कुछ है ना, डीपीएसपी में, लेकिन जस्टिसेबल नहीं है. तो आप और मैं, हम लोग क्लेम नहीं कर सकते, उसको एस्टैब्लिश नहीं कर सकते एज अ मैटर ऑफ राइट इन कोर्ट ऑफ लॉ. करेक्ट. सो व्हेन वी आर टॉकिंग अबाउट these privileges pertaining to privileges or rights pertaining to legislators, if they are not justiciable, then what is the value and position of these rights under this jurisdiction? इसका कोई मतलब नहीं रहेगा. अननेसेसरी डेकोरेशन है. समझ में आई कुछ बात? अरे कहते था, हाँ राइट. सो पहला क्वेश्चन हमारा ये है कि जस्टिसेबल है कि नहीं. अगर हम लोग बोले हाँ जस्टिसेबल है, ऑफ कोर्स आपके लेजिस्लेटर्स तो बिल्कुल बोलेंगे जस्टिसेबल है, तो किस हद तक? नेक्स्ट क्वेश्चन ये होता है कि टू व्हाट एक्सटेंट. अब आपका जो जुडिशियरी ने इसको जस्टिसेबल बोला हुआ, क्योंकि उन्होंने बोला इसकी लिमिटेड जुडिशियल स्क्रूटिनी हो सकती है. किसकी? प्रिविलेजेस की लिमिटेड जुडिशियल स्क्रूटिनी हो सकती है. मतलब नहीं लिखा हुआ, कन्वेंशन है तो फिर भी कन्वेंशन अगर वायलेट होता है तो उसके बेसिस पे आप कोर्ट में जा सकते हो, बोल सकते हो कोर्ट को कि देखो ये कन्वेंशन है लेकिन ये वायलेट हुआ, तो इसकी आप जुडिशियल स्क्रूटिनी कर सकते हो. There is a room for debate in the light of broader principle of separation of powers. अब मैं अगर आपको ये समझाता हूं, मैं अगर एक क्वेश्चन पूछूं, आप कंटेम्प्ट ऑफ जुडिशरी हुआ, somebody spoke something against judiciary in words which are highly disrespectful, compromising dignity, image of the court in public. In such case, which institution are you going to approach if you want to make a complaint? Judiciary, obviously. Or at the max, you will go to Attorney General and you may ask Attorney General to file an affidavit. I would say like file a petition, bring it to the notice of the court that this particular statement spoken or maybe written or maybe published by XYZ person amounts to your contempt. Attorney General जाके बोलेंगे. Who would take an action against it? नोटिस कौन इशू करेगा? जुडिशरी. कंटेम्प्ट किसका हुआ था? जुडिशरी. नोटिस भी इशू जुडिशरी करेगा. मैटर फाइनलाइज कौन करेगा? जुडिशरी खुद ही करेगा, क्योंकि कंटेम्प्ट जुडिशरी का है ना. सही है बात? गुड. अब अगर हम लोग ये बोले, ध्यान देना प्लीज सब लोग, अब अगर हम लोग ये बोले कि कंटेम्प्ट यहां पे लेजिस्लेचर का हुआ, प्रिविलेजेस है ना, वायलेट हुआ, मैंने कुछ कमेंट कर दिया लेजिस्लेचर क्या दिया, फैक्चुअली इनकरेक्ट है, मतलब मैंने इंटेंशनली बोल दिया कुछ, मान ही लो, है ना. तो कंटेम्प्ट हुआ लेजिस्लेचर का. तो स्पीकर ऑफ पार्लियामेंट जो है लोकसभा, उन्होंने बोला कि दिस पर्टिकुलर स्टेटमेंट ऑफ दिस पर्टिकुलर इंडिविजुअल इज वायलेटिव ऑफ आवर डिग्निटी एंड दिस पर्सन मस्ट बी अरेस्टेड. लेकिन मुझे पकड़ना. नाउ हु वुड डिसाइड द केस? And why do you think judiciary should decide that? While discussing about judiciary, you didn't say that legislature will decide the case. Judiciary का contempt हुआ तो legislature decide करेगा, और legislature का contempt हुआ तो judiciary decide करेगा. तब मानते हैं. हम लोग देखो यहाँ पे क्या बोलते हैं. There is a room for debate in the light of broader principle of separation of powers. If judiciary is to, even if limited scrutiny of principles, privileges or those conventions, even if it is a limited scrutiny by judiciary, the matter is, don't you think that then this would violate the idea of separation of powers? Contempt हुआ, बिल्कुल हम लोग मानते हैं contempt हुआ, है ना. आपको मालूम है आर्गुमेंट क्या किया गया था ऑन बिहाफ ऑफ लेजिस्लेटिव स्टेट ऑफ महाराष्ट्र इन सुप्रीम कोर्ट, in front of the bench constituted by the court. Today, Chief Justice was the principal judge in that bench. The argument on behalf of Maharashtra State Legislative Assembly was, this court doesn't enjoy power under this Constitution of India to look at this case and entertain or decide the matter. The matter of privileges is essentially a matter of legislature, and the speaker of the legislature is constitutionally a correct agency to decide those matters. Of course, court denied this. That is different story, you know. But this was the argument. This is the point of view. That's why I said that separation of powers के idea को चलते, उसके चलते आपको ये देखना पड़ेगा कि judiciary scrutiny करेगी, तो क्यों? Limited हो या पूरी हो, उससे कोई फर्क नहीं पड़ता. लेकिन ये है कि क्यों privileges किसके हैं? अच्छा चलिए, जो जजेस है ना, जजेस, उनके रिमूवल के सिवाय कभी आपने ये देखा है कि लेजिस्लेचर में जजेस के कंडक्ट के ऊपर कोई डिस्कशन हुआ है ना? नहीं होगा. 121 आप पढ़ो, नहीं होगा. क्यों नहीं होगा भाई? क्या दिक्कत है? मतलब अगर किसी लेजिस्लेटर के कंडक्ट के ऊपर और उसका अगर प्रिविलेज वायलेट हो तो आप जुडिशरी में जाके डिस्कस कर सकते हो. तो फिर वो यहाँ पे क्यों नहीं? जो इंडिपेंडेंस हम लोग जुडिशरी को देखते हैं, क्या वो इंडिपेंडेंस हम लोग, हमारा कॉन्स्टिट्यूशन लेजिस्लेचर के लिए इंश्योर करता है कि नहीं करता? ये सोचने जैसी बात है ना. इसीलिए प्रिविलेजेस के ऊपर अगर कुछ क्वेश्चंस तैयार होंगे तो आपको हमेशा न्यूज़पेपर में मिलेगा. इसके ऊपर आपको यू आर नॉट गोइंग टू गेट एनीथिंग रिटन एट लेंथ इन एनी डैम बुक दैट यू आर रेफरिंग फॉर यूपीएससी. कुछ नहीं मिलेगा आपको. अगर कुछ ढूंढना है इसके ऊपर, अगर क्वेश्चन आता है 10 से 15 मार्क का, है ना, आपको न्यूज़पेपर के ऊपर ध्यान रखना है. मैं अभी बता रहा हूँ, क्योंकि देखो इशू क्या क्रिएट होगा, यूपीएससी क्या पूछेगा, ये एंटीसिपेट करना थोड़ा डिफिकल्ट है. हाँ, मैं आपको पॉसिबल लूपहोल्स क्या है, कहां से क्वेश्चन रेज हो सकता है, तैयार हो सकता है मेंस के लिए, वो बता रहा हूँ. तो हमारे पास ये दो क्वेश्चन। अब हम लोग देखेंगे इसको, ये दो क्वेश्चंस को, या फिर ये इसको कैसे आंसर करना है, क्या क्या हुआ इंडिया में। बोलो। It is very difficult to say that the Speaker of the House acts as a tribunal or acts in the capacity of a tribunal. क्योंकि इंडिया में ऐसी ऐसी चीजें हो चुकी है ना इसको लेके। लेजिस्लेचर ने मतलब कोर्ट के जजेस को नहीं छोड़ा है, उनको समन किया था, आ जाओ तुम, देखते तुम कैसे हमारा केस लेंगे। तो ये बहुत डिफिकल्ट है ये अभी इस तरह का कंक्लूड करना कि नहीं स्पीकर एक्ट्स एज अ ट्रिब्यूनल हियर। ये हम लोग क्यों बोल रहे हैं एंटी डिफेक्शन में, क्योंकि हमने खुद नहीं बोला, ये तो कोर्ट ने बोला ना, कि कोर्ट ने बोला कि अंडर एंटी डिफेक्शन लॉ द स्पीकर ऑफ असेंबलीज इज परफॉर्मिंग द ड्यूटीज एज इट इज अ ट्रिब्यूनल, और तो एवरी ट्रिब्यूनल कम्स अंडर अस। तो हमने लॉजिकली तो एक्सेप्ट कर ही लिया, मतलब हाँ हाँ ठीक है बिल्कुल ठीक है, बिकॉज वी आर सेइंग दैट व्हाट इफ स्पीकर गोज रॉन्ग, then you need to have somebody to appeal to, है ना। what if that somebody goes wrong, तब कहाँ जाओगे आप, मतलब somebody कौन, कोर्ट, है ना। कोर्ट तो बहुत सारी जगह पे रॉन्ग गया होगा, तब तो हमने कोई क्वेश्चन नहीं किया, क्योंकि वो पॉलिटिकली करेक्ट, कॉन्स्टिट्यूशनली हो या ना हो, पॉलिटिकली तो वो करेक्ट है, तो करेक्ट है जब पॉलिटिकली तो हमने बात नहीं की उसके ऊपर, है ना। समझाऊंगा मैं आगे जाके, ठीक है, आगे चलते हैं। A strict separationist view would favor an absolute bar on judicial scrutiny, as I was discussing this. Strict separationist view, idea of separation of power, वो बोलेगा कोर्ट का यहाँ पे कोई काम नहीं बनता। Absolute bar on judicial scrutiny on the matters pertaining to privileges. One, an intermediate position would allow for historical inquiry into existence of privileges. इंटरमीडिएट व्यू मतलब जो ना ज्यादा स्ट्रिक्ट है ना ज्यादा माइल्ड है ना। ऐसा व्यू क्या बोलेगा, देखो वो बोलेगा कि कहां से आए थे ये प्रिविलेजेस, हिस्टोरिकल ओरिजिन है उनका। तो अगर जुडिशरी को कुछ करना है तो सिर्फ किसी एक प्रिविलेजेस, वो प्रिविलेज है कि नहीं है इसको देखने के लिए बस वो हिस्टोरिकल स्क्रूटिनी कर ले। अगर हिस्ट्री में कहीं वो प्रिविलेजेस को प्रैक्टिस किया गया है तो जुडिशरी ने हाँ बोलना चाहिए, सही है। बाकी कॉन्स्टिट्यूशनल लॉजिक वगैरह ये बाकी चीजें उसमें नहीं अप्लाई करना चाहिए। एक मिडिल व्यू है। द लिबरल व्यू, द एक्सपांसिव व्यू अबाउट वुड imply that the courts can inquire into both the existence of the privilege and the merits of it. समझी बात कुछ, समझे नहीं समझा। एक एंड में क्या बोला, नहीं अलग रखो इसको, प्रिविलेजेस किसके, लेजिस्लेचर के, कोर्ट का कोई लेना देना नहीं। दूसरा व्यू क्या बोलता है बीच में, नहीं लेजिस्लेचर की प्रिविलेजेस हो सकते हैं, है ना, लेकिन उसकी हिस्टोरिकल इंक्वायरी हो सकता है कोई प्रिविलेज जो कन्वेंशन से तैयार हुआ, वो कन्वेंशन हिस्टोरिकली एस्टेब्लिश नहीं हुआ है, रॉन्ग इंटरप्रिटेशन करके कोई प्रिविलेज अगर लिया जाए, क्लेम किया जाए तो उस केस में हिस्टोरिकल इंक्वायरी हो सकती है। यहां तक एक व्यू मानता है, पूरी तरह कोर्ट का रोल डिनाई नहीं करता ये। तीसरा व्यू ये बोलता है नहीं, हिस्टोरिकल इंक्वायरी तो होगी ही, उसके साथ साथ वो जो कन्वेंशन, जो प्रिविलेजेस है, उसका मेरिट भी टेस्ट होगा। अब ये कैसे टेस्ट होगा, ऑन द टचस्टोन ऑफ कॉन्स्टिट्यूशनल वैल्यूज। तीसरा लिबरल और एक्सपांसिव व्यू ये बोलता है कि कोर्ट इन इंडिया हैज पावर टू डू दिस। समझी कुछ बात। अगर आपके कॉन्स्टिट्यूशन में, ध्यान दे रहे हैं एकदम सही से, अगर आपके कॉन्स्टिट्यूशन में आइडिया ऑफ सेपरेशन ऑफ पावर रिजिड होता तो पहला स्टेटमेंट सही है ना, है ना, एकदम बिल्कुल सही है। दूसरा स्टेटमेंट जो है वो इसेंशियली इंग्लैंड के प्रैक्टिस पे जाता है। हिस्टोरिकल इवोल्यूशन को सिर्फ क्वेश्चन करोगे, मेरिट को नहीं। तीसरा स्टेटमेंट जो है वो एक्सपांसिव, आपको लिबरल दिख रहा है ना। अगर आप कोर्ट की नजर से देखो और मिसयूज ऑफ प्रिविलेजेस को ध्यान में रखो तो फाइनली यू विल बी कन्विंस्ड ऑफ द फैक्ट दैट द मेरिट एज वेल एज एग्जिस्टेंस ऑफ द प्रिविलेजेस must essentially be questioned by a third party, and here we have third party in the form of a court. And that's why courts interference in interpretation of privileges. But it is not very convincing. Not convincing from the point of view of idea of separation of powers. हमें दिखता यह है कि कोर्ट कन्वीनियंटली आइडिया ऑफ सेपरेशन ऑफ पावर्स को इंटरप्रेट करता है सिचुएशन वाइज, है ना? लेकिन इसके ऊपर इसका काउंटर आर्ग्यूमेंट हो सकता है। अभी जितना मैंने बोला उतना आपको समझा है, ये पहले बताऊंगा। एवरी वन ऑफ यू कळलेगा नक्की? आगे चलते हैं। विष्णु तू बोल क्या म्हणतोस? Yes, no, absolutely correct. Absolutely. There is no doubt about that. That aspect, like, why judiciary? If that is a question, to what extent can judiciary do it? The reason being, judiciary is the only organ in the state which is expert in the law and its evolution. So from that perspective, bringing these matters to the judiciary and the judiciary establishing it is absolutely correct, absolutely fine. But if that is so, then still the question remains, if we ask, because see, there would always be an argument if such matters which are essentially of a legislature's matters, why the court is trying to interfere, or maybe why the court is trying to lay it down. Because when it comes to conventions, right, the way they have evolved, the conventions essentially must be interpreted and must be interpreted by the agency which evolves them. Judiciary had never ever been a part of evolution of those conventions, neither in India nor in England. So from that perspective, because see what your constitution says, if the legislators in India would have the privileges enjoyed by legislators in House of Commons on 26th of January 1950. So something that they enjoyed on 26th of January 1950 are available to us. That is a statement used to be a statement in our constitution. Now, if that is so, and if we look at what is available, what was available to members sitting in House of Commons on 26th of January 1950, cannot be explained by the court in England, but it would be explained, or it can be explained only by the legislators sitting in the House of Commons, because they are the ones those who have evolved, and this is one of the logics, you can say, or idea that is used by H.M. Sirvai when he was H.M. Sirvai and M.S. Setalwad त्यांचं काय initial. So Setalwad and H.M. Sirvai, they actually were debating this matter in court of law. So Sirvai was of the opinion that if these privileges belongs to legislature and they have evolved by legislature in England, the legislature only should be permitted to speak and decide their scope and extent. And judiciary should not, beyond certain limit, interfere with it. Of course, this argument was not considered by majority. The majority took the argument which was favoring the court's presence in these matters, which was made by Satilwad. And then court finally established a trend in India that whenever matter of privileges comes in India, right, you have a court's door open and you can anytime approach the court. So these are two views pertaining to it. So one which stated by you is absolutely correct, but then HMCY wanted to force court within their limits, getting it, not trying to cross the same. And so the debate, and once court crossed the lines, वो debate continues. अगर कोर्ट नहीं करता तो बात फिर भी डिबेट होता, लेकिन बात अलग तरीके से होती. चलिए कोई बात नहीं, आगे चलते हैं. So incumbents have invoked legislative privileges to target political opponents and critics, often in cases that are better suited for adjudication by courts. इसको एकदम ठीक से समझो. Incumbents जो ऑलरेडी लेजिस्लेचर में बैठे हुए लोग हैं, इन्होंने बहुत बार ऐसे प्रिविलेजेस का प्रोटेक्शन लेके लोगों को टारगेट करने की कोशिश की है, अपोनेंट्स को टारगेट करने की कोशिश की है ना. और ऐसे मैटर्स में जहां पे ऑफन केसेस आर बेटर सूटेड फॉर एडजुडिकेशन बाय कोर्ट, जहां पे कोर्ट ने एक्चुअली बीच में आके एडजुडिकेशन करना चाहिए. तो जहां पे ये महाराष्ट्र का जो मैटर था, मैंने अभी थोड़ी देर पहले बताया आपको, वो डिफेमेशन वाला मैटर हो सकता था प्रैक्टिकली देखा जाए तो, है ना. लेकिन वो प्रिविलेजेस के मैटर में कन्वर्ट करके उसको प्रिविलेजेस का वायलेशन कंसिडर करके उसको प्रेजेंट किया गया. डिफेमेशन होता, एडजुडिकेशन बाय कोर्ट होता. प्रिविलेजेस हुआ, इसलिए एडजुडिकेशन बाय लेजिस्लेचर हो सकता है. सो लेजिस्लेचर ट्राइड टू इंटरवीन हियर. आई होप यू आर ऑल गेटिंग दिस व्हाट आई एम सेइंग. अर्नबची केस माहिती आहे ना तुम्हाला. ती डिफेमेशनची केस असू शकत होती, म्हणजे तसा विचार केला. पण डिफेमेशनची केस असेल तर कुठे जाईल? कोर्ट में जाएगा वो मैटर. तो कोर्ट में एडजुडिकेशन के लिए कितना टाइम? It will take lot of time. Instead, if you want to resolve matter on the floor with immediate effect, take a help of privileges. You take privileges as a shield, right? And then under this shield, you can actually bring any matter that otherwise is suited for court's inquiry. So as Vishnu, as you say, the legislature has also tried to this way misuse the privileges. और इसलिए कोर्ट का रहना जरूरी है, या फिर है, समझ में आता है कि हाँ कोर्ट का रहना जरूरी है. आगे देखिए. They have also been used as a method of disciplinary control in response to allegations or wrongdoing by the lawmakers. Lawmakers, legislators themselves. आप अपोजिशन में बैठे हो, ये लोग पोजीशन में बैठे हुए, इन्होंने कुछ क्रिटिक करना था, वो क्रिटिक करते करते कुछ बोल दिया, आपने इमीडिएटली चालू किया नहीं प्रिविलेज वॉलेट को. तो स्पीकर बैठे ही है, एक्सपेक्टेड ये है कि स्पीकर न्यूट्रली देखे चीज, तो देखेंगे नहीं, लेकिन आजकल तो नहीं. तो उनको पनिशमेंट जल्दी हो सकता है. महाराष्ट्र स्टेट लेजिस्लेटिव असेंबली को याद करो, याद आ रहा है ना आपको? वैसे तो आप राज्यसभा को भी याद कर सकते हैं, लेकिन यहाँ पे महाराष्ट्र स्टेट लेजिस्लेटिव असेंबली में आपको बिल्कुल मालूम है कि 12 लोगों को हमने सस्पेंड किया था इंडेफिनिट पीरियड के. स्पीकर के पास नहीं है पावर. अच्छा चलिए, स्पीकर नहीं, कोर्ट के पास भी पावर नहीं है कि कोई इंडेफिनिट पीरियड के लिए कोई पनिशमेंट दे. जितना लॉ में लिखा गया उतना पनिशमेंट हो सकता है. आपकी कॉन्स्टिट्यूशन में लिखा गया ना कि अगर सस्पेंशन होगा, रूल बुक में भी है, सस्पेंशन होगा तो मैक्सिमम कितने टाइम का होगा. इंडेफिनिट कैसे कर सकते हो आप? बात समझ में आ रही है कुछ? तो इफ वी रिलाई ऑन लेजिस्लेचर्स फॉर एडजुडिकेटिंग मैटर्स पर्टेनिंग टू प्रिविलेजेस और देयर रूल्स, legislatures have not shown their integrity towards law in post-independence India, and that is precisely the reason why your court has intervened on number of occasions and decided the matters. बात समझ में आ रही है? तुम्हाला लक्ष द्यावं लागेल बरं का व्यवस्थित. आणि इथून पुढे पण बऱ्याच वेळामध्ये व्यवस्थित लक्ष द्या. So the debate has centered on whether this is proper when there are other remedies available. जब बाकी रेमेडीज है, कोर्ट में जब जा सकता है तो लेजिस्लेचर प्रिविलेजेस को सामने लाते फिर क्यों कोई मैटर लो. तो इसलिए डिबेट यहाँ पे. Such a situation appears to be such substitution appears to be a faster response to corrupt practices by legislators when compared with the slow pace and dilatory nature of judicial proceedings. जुडिशरी में जितना टाइम लगेगा उतना टाइम वेस्ट करने से अच्छा है कि आप फ्लोर पे उस मैटर को प्रिविलेजेस के कॉन्टेक्स्ट में जल्दी से जल्दी निपटा लो. Accordingly, privileges can be used as instruments to combat wrongdoing within the legislature, apart from serving as shield against the undue external pressures. चलिए एग्जाम्पल इसका पॉजिटिव पे देखते हैं हम लोग. 2G स्कैम हुआ है ना, अभी नहीं हुआ है, अभी तो नहीं है ना, मतलब पहले था अब नहीं है. जब वो स्कैम था तो उस केस में वो जो मिनिस्टर ऑफ टेलीकॉम उस वक्त जो थे ए राजा है ना, he was prosecuted on the floor also. He was forced to resign and then he was like brought in the court. That is different story, right? In similar manner, after this new government coming into power into 2014, Rohit Vemula wala case came to the surface, and the then Minister of Education made a comment on the floor that was factually incorrect, and against her immediately privilege motion was moved. However, the ruling party could manage to dominate it. That is a different story. But a privilege motion was moved. Now, what is this? This is basically a tool used by the legislators sitting to control themselves. उनको कंट्रोल करने के लिए यूज किया गया टूल है. तो जैसे मैंने आपको बताया, जैसे एक्सटर्नल एजेंसी के अगेंस्ट कंट्रोल हो सकता है, उसके इन्फ्लुएंस को रोकने के लिए जैसे हो सकता है, वैसे ही legislators themselves, if they misbehave, if they make statements which are unparliamentary, if they use language that is unparliamentary, if they do something, their actions and activities, if those activities are not good enough to maintain the dignity of the house, you will find the action would be taken against them in the form of violation of privileges of the house. So, this is basically two-edged sword that can be used by legislators against its own members as well as against those who are outsiders. Clear? Everybody? Good. So that was introduction. Let us now talk about justification of legislative privileges. Rule of law. The ideal of rule of law implies that the lawmakers should be subjected to the law which they create, just as they would bind the citizens. Correct? ये देखा है हमने पहले इससे कि नहीं? असेल तुम्हाला माहिती असेल सर, देखा है नहीं देखा हमने? कहाँ देखा है? Article 14, no one is above law. Idea of rule of law, equal subjection of all citizens to an ordinary law administered by ordinary law courts. काय आठवते का असं काही आठवते आधीच? दिवाळीनंतर तुमची मेमरी फारच कमी झालेली अशी जाणवते मला. The idea of rule of law says that those who make laws, the same law is applicable on them, as is the case with other citizens. By that standard, the conferral or granting of an exercise of legislative privileges appears to be an anomaly. Now, please understand this. Understand this very well. We are saying that rule of law says no one is above law. No one is above law. Whether you are politically high or low, very well established or not, law doesn't care about it. Barabar? But then why then separate privileges are given to the members sitting in the legislature? Don't you think that this is basically favorable treatment given to the members sitting in the legislature? You know some of the privileges? They cannot be sued in court of law on the matters, whatever they said, whatever they did on the floor. Why is that? Is it the case that their freedom of speech on the floor and our freedom of speech in public are not equal? Is it the case that they don't derive their freedom of speech and expression out of Article 19 Clause 1A, as there is a separate provision in the Constitution in 105, and we derive it from 19 Clause 1A? Shall we consider that our Article 19 Clause 1A is of a lesser significance and lesser constitutional importance than that of 105, which accords privileges to the members of the parliament, particularly of free speech? This was a question which was discussed in court. We will see that you may not agree with what court says, but there is no other option but to agree, because that is what is present situation. मेरा क्वेश्चन सिंपल है, जिनको नहीं समझा अभी मैंने क्या बोला उसके लिए वापस बता रहा हूं. हमारा फंडामेंटल राइट 19 क्लॉज 1A और आर्टिकल 105, वो बाद में देखना क्या आर्टिकल है, देखेंगे हम. 105 जो लेजिस्लेटर्स जो होते हैं, आपके मेरे रिप्रेजेंटेटिव जो है, उनके फंडामेंटल राइट, सॉरी, उनके राइट टू स्पीच एंड एक्सप्रेशन की बात करता है विद इन 4 वॉल्स ऑफ द हाउस. इन दोनों की कंपैरिजन की बात चल रही है. इसमें से कौन सा ज्यादा इंपॉर्टेंट है और कौन सा कम इंपॉर्टेंट है कॉन्स्टिट्यूशनली, कि दोनों सेम है? या फिर क्वेश्चन ऐसे होना चाहिए, क्या दोनों सेम है कि अलग अलग है? अगर अलग है तो सुपीरियोरिटी और इंफीरियोरिटी उसको देखना पड़ेगा हमें, इसमें से सुपीरियर कौन है, इंफीरियर कौन सा है. अगर अलग नहीं है, सेम ही है, तब तो शायद आधा डिबेट यहां से खत्म हो जाए. तो जो बैठे हुए वहां पे ना, उनकी कोशिश हमेशा से ये रही है कि उनका फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन which is given in 105 is of a greater constitutional importance than an ordinary citizen's freedom of speech and expression. Though some of the judges in the court didn't agree with this, however, they all inked their judgments which were minority judgments. Majority, on the other hand, upheld this view that probably 105 accords, or 105 is constitutionally far more important. It is very difficult to digest such types of things, but then still, लॉजिक देखेंगे उसके पीछे. तो ये पहला पैराग्राफ सबको समझा, एवरीबडी, काय प्रश्न क्या अप्लाइड है. अगर रूल ऑफ लॉ सबको सेम देखता है तो प्रिविलेजेस अलग से कैसे दिए गए, है ना? आगे. However, the differential treatment accorded to incumbent legislator is justified in the light of their duties as a particular class of public officials. क्या? Particular class of ऐसे बीच में किसी ने बोला था, कोणीतरी म्हणाल होतं मीडियामध्ये, नाही आठवते? आठवलं की नाही आठवलं? कोणाला आठवलं सांगा बरं. अच्छा, त्यांनी म्हटलं होतं का? बरं, मग कोण आहे? If not an ordinary citizen, then who? Particular class of public officials. See the argument. आपको ना बिल्कुल ध्यान से सुनना पड़ेगा इस चीज को. वो आपके रिप्रेजेंटेटिव है ना, तो सिटीजन है कि नहीं है? अच्छा है, सिटीजन है. इन्होंने बोला कि ये पर्टिकुलर क्लास ऑफ पब्लिक ऑफिशियल्स होते हैं. The ability to speak and vote inside the legislature without fear of intimidation or punishment is considered to be intrinsic to the role of an elected representative. So it is very important. अब उन्हीं के कॉन्टेक्स्ट में देखेंगे. आप बैठो as if you are sitting in the legislature of state of Maharashtra, ऐसे समझ लो खुद को, है ना? आप में से हो ही सकता है कि कोई कल को जाके सीएम बनेगी या फिर लेजिस्लेटर बनेगी. फिलहाल सोच ही लो, इमेजिन करो, है ना? आप बैठ के ये बोल रहे हो कि देखो मेरी जो my ability, my power, my freedom to speak and vote inside legislature without any external influence fear and intimidation or punishment without an external influence is considered to be, it is very intrinsic to role that I am going to play in the legislature. That means my freedom of speech and expression must at any cost be protected. You are sort of, trying to claim the fact that my freedom of speech and expression here in the assembly is absolute. आप यही क्लेम करने की कोशिश करो. ये एब्सोल्यूट है नहीं, बात अलग. वो हाउस के रूल्स होते हैं, स्पीकर है, रूल बुक है, ये सब चीजें हैं, लेकिन इसको 2 मिनट बाजू में रखना. आप यहाँ पे क्या बोल रहे हैं? आई एम अ डिफरेंट क्लास ऑफ अ पब्लिक ऑफिस एंड माय फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन इज इंट्रिंसिक टू डिग्निटी ऑफ दिस हाउस एज अ होल. आप आपका फ्रीडम नहीं बोल रहे, आप ये बोल रहे हो मैं मेरी बात करने की आजादी ये पूरे हाउस के इंटीग्रिटी के लिए जरूरी है. तो मेरा फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, आप इनफैक्ट ये क्लेम कर रहे हो कि बाकी लोग जो ऑर्डिनरी सिटीजन है उनके फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन से शायद अभी फिलहाल शायद यूज करते हैं, शायद ज्यादा इंपॉर्टेंट है. तो देखा जाए वैसे देखा जाए तो शायद आप ये मान सकते हो कि हाँ ऐसे हो तो सकता है शायद, है ना. विष्णु इनकम जस्ट है ना. तो हम लोग शायद मान सकते हैं, लेकिन फिर भी आगे चलिए, क्योंकि ऐसे ही इवोल्यूशन हुआ है इसका. आप प्लीज ध्यान रखो इस चीज को. या आज का क्लेम क्यों है ऐसे? क्योंकि इसी तरह से इवोल्यूशन कोई वहां पे था इंग्लैंड में जिनको मेंबर्स ऑफ ग्लोबल हाउस जो है वहां पे, वो जो कुछ बात करते थे, जो कुछ एक्सप्रेशंस थे वो पसंद नहीं आए, तो इसलिए उनके ऊपर एक्शन लिया गया ना. तो उसी चीज से इसका इवोल्यूशन है. तो आप आज वही लॉजिक देके ये बोल सकते हो कि देखो मेरा फ्रीडम यहाँ पे लेजिस्लेचर में बैठ के सॉर्ट ऑफ एब्सोल्यूट ही होना चाहिए. In United Kingdom, parliamentary privileges was first asserted as pre-existing rights that were enforceable against the prerogatives of crown as well as judicial authority. Already existing है. अब ये कहाँ से already exist? वहां पे तो भाई कॉन्स्टिट्यूशन नहीं लिखा हुआ, कोडिफाइड कुछ नहीं है, तो कहाँ से already existing है? देखो उनके पास फ्लेक्सिबल है ना आइडिया ऑफ सेपरेशन ऑफ पावर्स, है ना. वहां पे ये क्लेम किया जा रहा है, they asserted these as pre-existing rights which were enforceable against the prerogatives of crown, you know, special powers you can say of a crown as well as that of judicial authority. For the House of Commons, they included protection against special rights of the House of Lords. House of Lords is still today also is considered to be far more closer to the crown. You can imagine the situation then in medieval England. In fact, those who used to sit in the House of Lords were far more closer, in fact, protecting the interests of nobility. Whereas those who used to sit in the House of Commons, even today, मानने के लिए तो आज बोल ही सकते, used to protect the interests of commoners. इसलिए House of Lords and House of Commons बोला जाता है उसको. Commons मतलब third stage. Directly अगर हम लोग देखें, Lords मतलब first stage. है ना, feudalism वहां पे भी था. समझ में आ रही है बात आपको? तो कॉमनर्स ने क्या किया? कॉमनर्स ने अपना फ्रीडम ऑफ स्पीच प्रोटेक्ट किया. इसके अगेंस्ट? क्राउन और जुडिशियल अथॉरिटी के अगेंस्ट, है ना. अब उस वक्त की जुडिशियल अथॉरिटी मतलब जजेस कौन थे? आप थोड़ा पीछे जाके देखोगे तो वहां पे सबके नाम के पहले आपको लॉर्ड शायद लिखा रहेगा, मिलेगा, या फिर सर लिखा मिलेगा. सर तो नाइटहुड है विच यूज्ड टू बी कन्फर्ड बाय द क्राउन, एंड that used to be an indication, even आज के डेट में भी, is indication of the fact that a person who has been conferred with the knighthood would remain loyal to the crown. बात समझ में आ रही कुछ आपको? है ना, मैं बस होप ही कर रहा हूँ कि आपको समझ में आ रहा है. ध्यान देना लेकिन. So for the House of Commons, they were included. They included protection against special rights of the House of Lords. This can be characterized as an effort to resist the power of other two branches that were closely aligned with the royal authority. That's what I say. Judiciary and House of Lords there, as well as executive, है ना, ये पूरा का पूरा रॉयल अथॉरिटी के साथ क्लोजली अलाइन. तो इनके अगेंस्ट हाउस ऑफ कॉमन्स खड़ा है. आप इसको ऐसे देखो, आप समझ लो कि आज अभी मिडिवल इंग्लैंड में बैठे हुए आप लोग हो, यहाँ पे हाउस ऑफ कॉमन्स में बैठे हो, आप थर्ड स्टेट के रिप्रेजेंटेटिव्स हो. अगर आपने हिस्ट्री, वर्ल्ड हिस्ट्री सही से पढ़ा हुआ है तो, है ना, थर्ड स्टेट के रिप्रेजेंटेटिव्स हो, तो आप किसकी बात रखोगे? कॉमनर्स की, अगेंस्ट हुम? वही सिस्टम को इमेजिन करो जहां पे टैक्सेस कलेक्ट किए जाते हैं सिर्फ आपसे, जहां पे रिस्ट्रिक्शंस है सिर्फ आपको, जहां पे आपके पास कोई खुद की अपनी प्रॉपर्टी नहीं है ना, और जो नोबिलिटी है उनसे कोई टैक्स कलेक्शन नहीं है, उनको सभी चीजों की छूट दी हुई। ऐसे कॉन्टेक्स्ट में आप किसकी बात रखोगे? आप अगर क्रिटिकल बोलोगे तो किसके अगेंस्ट क्रिटिसाइज करोगे? यू विल बी क्रिटिसाइजिंग द court, you will be criticizing even any order of the court, you will be criticizing the laws, right? You will be criticizing the crown, and why would you think then crown would spare you, or crown would not, consider you as an element of discontent represented in the house? So इसीलिए एक्शन होगा। अब इस कॉन्टेक्स्ट में अगर आप देखोगे आज जो, अच्छा चलिए, इस कॉन्टेक्स्ट में अगर आप देखोगे तो आप वहां पे बैठ के अगर आपके राइट टू फ्री स्पीच एंड एक्सप्रेशन क्लेम कर रहे हो, असर्ट कर रहे हो, तो इसमें कोई गलती नहीं है, क्योंकि वही असर्शन होगा शायद कॉमन मैन का, शायद बरोबर है कहा, है ना? ये बात वहां पे इसी तरह से इवॉल्व हुई, फाइनली एस्टेब्लिश हो चुकी, ठीक? एवरीबडी, जो इवॉल्व हुआ और जो एस्टेब्लिश हुआ, जो प्रोसेस से इवॉल्व हुआ और एस्टेब्लिश हुआ, वो एस्टेब्लिश चीजों को हमने कैरी किया। अब एस्टेब्लिश चीज का मेरिट आपको अगर देखना है तो आप इवोल्यूशन के प्रोसेस को तो देखोगे। इवोल्यूशन के प्रोसेस में ही जड़ है उसका, इसका, इस आइडिया का, कि पब्लिक ऑफिशियल से अलग टाइप के, तो उनका फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन उस इंस्टीट्यूशन के इंट्रिंसिक हेल्थ के लिए जरूरी है, तो उनका फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन ऑफ अ सेपरेट कैटेगरी होना चाहिए। हमारे यहाँ पे अब लॉर्ड्स नहीं है ना, हमारे पास किंगडम है कोई, है ना, लेकिन आपके लेजिस्लेटर्स जब बैठेंगे वहां पे लेजिस्लेचर में, वो क्लेम तो यही करेंगे। बात समझी सबको? बात समझी सबको? Through the decades leading up to English Civil War, thereafter, parliamentary privileges emerged as a significant check on excesses by the crown. They evolved through specific assertions, often recognized by the way of litigation. ध्यान दो इसके ऊपर। क्यों एस्टेब्लिश हुआ उसका ऑथोरिटी? Have been practiced for centuries together, but that's not the only reason. They have been claimed, asserted and established at times through litigation. मतलब कोर्ट में जाके लॉ एस्टेब्लिश करवाया। Their early history suggests that they were chiefly used to protect the legislators from arbitrary arrest and persecution and suspension at the behest of the monarch. समझ लगा? Are you all getting this? Everybody, है ना? ये उसकी हिस्ट्री है। As a reflection of this history, Article 9 of Bill of Rights in 1689 provided that the freedom of speech and debates and proceedings in the Parliament ought not to be impeached or questioned in any court or place outside the Parliament. है ना? वो जो Bill of Rights है 1689 आर्टिकल 9 में क्लियर लिखा हुआ कि जो पार्लियामेंट में होगा वो पार्लियामेंट में रहे। आप बात समझी? जो स्टेट लेजिस्लेचर में होगा वो स्टेट लेजिस्लेचर में होगा, उसके बाहर उसके ऊपर कोई क्वेश्चन नहीं रेज हो सकता, क्वेश्चन नहीं रेज। आप क्रिटिसाइज कर सकते हो, आपका मेरा फंडामेंटल राइट बनता है, वो बात अलग, उसकी बात नहीं कर रहे हैं हम। You cannot question it, you cannot adjudicate the matter that has happened inside the four walls of the house. That matter must be adjudicated and settled inside the house only. No external authority outside house, can interfere in the thing. Similar language can be found in Article 1(6) of the United States of American Constitution, which was framed nearly a century later. Subsequent history includes situations where the British Parliament invoked its privileges to impose penal consequences, such as imprisonment and fines on outsiders, as well as expulsion of its own members. है ना? हमने ये महाराष्ट्र स्टेट लेजिस्लेटिव असेंबली ने कहां से सीखा कि कोई आउटसाइडर जो इसको इंप्रिजन किया जा सकता है अगर वो कुछ बोलता है तो आप क्या बोलते? देखो, इंग्लैंड से सीखा। पढ़ो ये पैराग्राफ, है ना? यूएस के कॉन्स्टिट्यूशन में भी आपको ये दिखेगा। उसके बाद जो भी हिस्ट्री ब्रिटेन के कॉन्टेक्स्ट में हम लोग देखते हैं, जहां जहां ब्रिटेन के लेजिस्लेटर्स, लॉ मेकर्स ने आउटसाइडर को पनिश किया, इम्प्रिजन किया, या फिर सिटिंग लेजिस्लेटर को भी पनिश किया या फिर इम्प्रिजन किया फॉर वायलेशन ऑफ दोज प्रिविलेजेस, all such incidences went on to set a trend. एक ट्रेंड सेट कर दिया उन्होंने, and that trend is nothing but convention, which is followed in America, which is followed almost across the globe. I would say all those countries which used to be controlled earlier during colonial time or during the time of imperialism by England used to be governed by England laws or laws passed by British Parliament. You know, all such countries are still today following these sort of privileges based on conventions. समझ में आई बात? Everybody. अब ये कन्वेंशंस अगर सालों से चलते आए और एस्टेब्लिश हुए, तो अब आज नया लॉ बना के आप अलग क्या बना लोगे उससे? मतलब आपने पूरा आपका जो लेजिस्लेचर है वो बोरो किया इंग्लैंड से, और कन्वेंशंस के लिए आपने अपना खुद का दिमाग लगा के सॉरी प्रिविलेजेस के लिए वो लिख डाले, तो ये बहुत वो सही नहीं जाएगा, है ना? तो वही सिस्टम को हमने सॉर्ट ऑफ कॉपी पेस्ट किया इंडियन कॉन्टेक्स्ट. Legislatures created during colonial period looked to the British parliamentary practices. The earliest instances of use of legislative privileges have been traced back to the rule of East India Company in Bengal. During the direct rule of British government, the provincial legislatures invoked them to insulate themselves from judicial scrutiny, particularly to protect the serving legislators from impending arrests. इंडिया में भी हुआ है. अब देखो इंडियन हिस्ट्री आ गई यहाँ पे. बंगाल में आपको देखना पड़ेगा ड्यूरिंग कंपनीज रूल. अब देखो कंपनी के रूल में उस वक्त कोई बहुत बड़े लेजिस्लेचर्स नहीं हुआ करते थे. आई होप यू probably might be knowing the size of legislatures during companies rule, right? There used to be the governor general and there used to be the governor of particular provinces, you know, right? And these governors used to have executive council and legislative council if you have gone through the books, right? And here we are talking about that legislative council. At the first place, these legislative councils or the councillors here, right, used to have very limited powers. Because governor used to have a veto, and using veto, he can at any time, you know, cross the arguments made on the council. Am I correct? Everybody, एवढं तरी हिस्ट्री तुम्ही वाचलेलं असेलच म्हणजे, है ना? Now, at times, what used to happen is the judiciary used to influence the legislators for their actions in legislature. So the governor, along with the legislators, used to fight for the sitting legislator and protect him or her. The first instance in Indian context took place in West Bengal. Today's West Bengal, the then Bengal province. So, अब आप मुझे बताओ कि इंडियन सॉइल पे पहली बार प्रिविलेजेस की अगर बात की हमने, तो वो कौन से ट्रेडिशन में बात की? तो मॉडर्न कॉन्टेक्स्ट में हमने इसेंशियली ब्रिटेन के प्रिविलेजेस या फिर ब्रिटेन के कन्वेंशन है उसी को हमने इंडिया में प्रैक्टिस किया. आपको यहाँ पे और एक चीज समझनी चाहिए. जो लेजिस्लेचर्स आपने देखे या फिर आप पढ़ोगे या फिर पढ़े रहेंगे आपने, जो इंडिया के फ्रीडम स्ट्रगल में तैयार हुए, है ना? Whether during companies rule, there was a dual rule. I hope you all know this. Dual polity, right? So whether during that time or after 1857, that is being more particular 1858, when Good Government of India Act 1858 came into existence, after that act also, all the legislatures which came into existence, I hope you know this. I'm talking about our last legislature which was in existence was in 1937. 1939 they all resigned, provincial legislators. Till that point of time, you'll find that all legislators and everything that happened in any legislature that was existing in India was absolutely according to British conventions. And it is for this reason that British laws and British conventions appears to have been followed as it is even after independence. The constitution makers did not bother to write it down separately. The reason being, we were habitual of the same. So those who were sitting in the Constituent Assembly, they were the ones, almost 90%, 95% of them, they were the ones, those who came into first parliament. And they were the ones, those who were there in the legislature, provincial legislatures in 1937 wala edition. They or their probably seniors were there in 1924 वाला provincial legislative elections. है ना, माहिती का तुम्हाला की नाही 24 ला पण आपल्याकडे इलेक्शन झालं होतं भारतामध्ये 1924 1937 फेब्रुवारी 1937 है ना. सो जे लोग provincial legislature मध्ये Congress went on to establish governments in 7 provinces. I hope you must be knowing out of 11, right? All these provinces had Congress majority, and these members basically, continued to become a member of Constituent Assembly of India. Same members later on got elected into first Parliament of India that was constituted in 1952, right? So they were the ones, those who had a knowledge of privileges, right? And they continued those privileges and conventions as it is in the first Parliament, second Parliament, and to a certain extent, some of them into third Parliament also. By that time, practices were very well established. Everybody. Good. So Section 71 of Government of India Act 1935 was precursor to the relevant provisions of Indian Constitution. लक्षात आहे, इंडियन कॉन्स्टिट्यूशन के ऐसे प्रोविजंस जो कन्वेंशन से प्रिविलेजेस से डील करते हैं, बस वो प्रोविजंस आपको सेक्शन 71 गवर्नमेंट ऑफ इंडिया एक्ट 1935 में मिलेंगे. कन्वेंशंस नहीं, प्रोविजंस डीलिंग विद प्रिविलेजेस. कन्वेंशंस नहीं, प्रोविजंस डीलिंग विद प्रिविलेजेस. यू कैन गेट इट इनटू गवर्नमेंट ऑफ इंडिया एक्ट 1935 सेक्शन 71. तो कॉन्स्टिट्यूएंट असेंबली में भी डिबेट हुआ इसके बारे में. एच.बी. कामत had demanded the codification of legislative privilege. मैंने बोला इसको कोडिफाई करो, है ना, उसको लिखो, जरूरी है, खुला नहीं छोड़ो. जो लिखा है उसके आप देख रहे हो कितने इंटरप्रिटेशंस है, जो नहीं लिखा उसका न जाने क्या होता है. नहीं, he said that let us write it down in order to mark a clean break from British precedent. उनका क्यों हम लोग कुछ लेके चले ना, लिख देते अलग से एक शेड्यूल ऐड कर देंगे हम लोग कॉन्स्टिट्यूशन. That will, clearly break us from British precedents or British history. Responding to these demands, Dr. Ambedkar described the difficulty of including a detailed schedule to list out permissible actions and defended the incorporation of privileges available to the House of Commons at the time, while also empowering the future Parliament to legislate on the subject under Indian Constitution. Article 105 deals with powers and privileges of House of Parliament, houses in the Parliament, their members and committees. So what happens here? H.B. Kamat said that let us write it down. So as to, at the first place, so as to avoid any confusion that may arise later on. And second, that will also establish a very clear-cut break from British link, right? Dr. Ambedkar said that it is not easy, to put it to the writing, the conventions which have evolved for centuries together. It is really very difficult. It is really very difficult. You can understand this if you go through the personal laws. The personal family laws होते हैं ना, family laws जो होते हैं, some of them are not written, not codified. You cannot codify them. They are very difficult to codify because there are so many traditions and practices which have evolved and which may need to be mentioned in a law. And law is essentially a technical subject, right? You cannot write something that is highly difficult to imagine in today's context. Sati, for example. So, just 2 मिनट के लिए समझ ही लो कि हाँ सती आज भी होता, तो आप कैसे लिखते उसको लॉ में, कैसे कौन से प्रोसीजर लिखते कि इस तरह से क्योंकि प्रोसीजर लिखना पड़ता आपको, इस तरह से सती होता तो ही सही होता, नहीं तो गलत हो जाता, whatever. So it is very difficult that way to put conventions or traditions, historically evolved practices in the form of words and law. Dr. Ambedkar denied this, said that no, it is difficult, so we will not, put it into writing. Instead, he said that he favored incorporation of the privileges available to House of Commons at that time, that is, at the time of adopting Indian Constitution, 26 January 1950. और इतना नहीं, आपकी कॉन्स्टिट्यूशन ने 105 में आगे ये भी बोला कि पार्लियामेंट ऑफ इंडिया में इफ सो रिक्वायर्ड राइट डाउन इट्स ओन प्रिविलेजेस. जरूरत पड़े तो अपने प्रिविलेजेस लिख सकते हैं. ऐसे नहीं किया उन्होंने कि हाँ पार्लियामेंट जो पहले एग्जिस्टिंग है उतनी रहेंगे, आगे कोई इवॉल्व नहीं होगा। पार्लियामेंट लिख सकता है नए प्रिविलेजेस अपने। सेम प्रोविजंस यू विल फाइंड फॉर स्टेट लेजिस्लेचर इन 194 ऑफ द कॉन्स्टिट्यूशन। तो होता हाँ बोला। Its own privileges. What do you think? Who would write it? If not Parliament, if not state legislature? Your question is correct. Is it not that you are simply asking a judge to decide his own case? है ना? खुद ही लिखेंगे अपने privileges. जो चाहे लिख दे फिर. There are no limitations. Who said that there are no limitations? Constitution itself is a limitation of Parliament's power to make a law. This also is a law, right? One. Second, no privilege in the form of a law would stand outside the court's purview or outside the court's jurisdiction to review the same. Every law, every legislative action of the state, to be reviewed by the court. Second. Third, if not Parliament and if not state legislature, which legislative body do you think is capable under this constitution to frame a law? There is no other. And so Parliament by law should decide about privileges. So उनको बोला गया कि if at all it is required to be brought down in the form of a law, only Parliament can do it. So at least देखो ये बात बिल्कुल सही है, लेकिन कहीं तो आपको ट्रस्ट करना पड़ेगा, है ना? So it is said that let Parliament decide, but please understand, Parliament cannot decide whatever they want because there are clear limitations on the Parliament. Whatever privileges that they would put down must fall within the broader meaning of the constitutional limits. And if not, you always have a chance to question the law passed by Parliament in court. Not a difficult thing at all. और दूसरा ऑप्शन नहीं है, जुडिशरी को नहीं बोल सकते हम लोग तुम लिखो, क्योंकि लिखना काम जुडिशरी का नहीं है, एडजुडिकेशन है उसका। तो ये डिफिकल्टी है। विष्णु, वेलकम टू यू। हाँ, थोड़ा सा मोटे नहीं बोल सकता। Please repeat. Where does? Right. First question, it is very difficult that way to decide, the second question, it is very difficult that way to decide whether we have this particular mindset or this portrayal of all the institutions, or I would say the perception of all these institutions as we commonly have. It is very difficult to say that it is colonial, right? And it has our own indigenous view also, right? We have always been trained through schools, maybe maybe through social institutions, to treat the government apparatus as a Maibab. Though Maibab word essentially comes from colonial Raj, but I didn't get the proper word to coin it here. So as a Maibab, this idea of Maibab in Indian context comes from ancient, most probably from medieval time, when the authority of king was established as the vice regent of a god. From that idea, we have got these perceptions developed. So our perceptions are basically historically driven. This is one of the reasons why we looked at foreigners, that is French, Dutch, and Portuguese, as well as English, as vice regent of God. Only when we could realize that they are not as good as our ancestors, being more particular, earlier kings or earlier kingdoms. Only then we thought of revolting against them, right? So English, Dutch, or maybe English parts or Western parts which came into India, we cannot 100% convincingly say that it is their traditions which we are following now. Yeah, partially we have English things, and partially we definitely have our own perspectives about the institutions. And that basically that basically decides the level of democracy operational or maybe functional in any country. So the same privileges, same laws, same constitutional ideals you can see are being practiced in UK, practiced in maybe US, maybe in some other countries, but at altogether different levels. That different level of practice of these things is owing to the fact that these countries did not, even if they had that history, they have crossed enough of time, to sort of forget or maybe sort of break that particular history and now evolve or now rely on modernity. And so probably I think that in India we have this particular situation. So that is an answer to your second question. And first question, sir. Right and duty, right. Yes, there is. Where there is a right, there is a duty. So where there is a privilege, there is a responsibility, right? The matter is, again, the answer is in the second question, which I have already answered. The matter is, your parliament and the representatives sitting in the parliament are reflections of your society. When your society doesn't seem to be mature enough to understand the significance of law and significance of rule of law, being more particular, it is very difficult to expect the same thing from the legislators. The legislators are essentially the product of that society. Now, the counter to this argument is, what was the matter with the first parliament and the second parliament, maybe third parliament, at least till third parliament? The members sitting in the first, second parliament, at least being more particular, first and second parliament, were less a product of Indian society and more a product of Western society. So they were far more westernized. They were far more, you can say, Western influenced, right? And that is the reason, precisely, why we see that difference in today's legislators and the behavior of legislature and the legislature which was there in maybe first 1.5 decade of India's independence. It is essentially because of that westernization and Western influence, you can see that the members of Constituent Assembly and the first parliament are the members, those who protested and could make a stand against the colonial power. Of course, there are other aspects to it, but it is because of that westernization that they could manage to make a stand, right? However, The matter is uh, they couldn't teach it fully, or they couldn't, I don't know, westernize बोलना शायद गलत होगा, but then still for अभी जो हम लोग discuss कर रहे हैं, they couldn't westernize sufficiently the next generation which was to come into the house, right? And that is most important issue that we are facing today. If we look at the states, you all can see the difference in the dignity as well as the proficiency at which different state legislatures are working. If you look at the state legislatures in presidency towns, which used to be presidency towns, that is Bombay, Madras, Calcutta, and Delhi, you'll find that these state legislatures here in today's states are far more disciplined and are far more are far more democratic as compared to other state legislatures which never had that experience prior to independence. This also gives us a convincing answer of the fact that there are privileges, and these privileges have been misused and disrespected more by those who had the greatest responsibility to protect and preserve them. The best example of this, because ये एग्जाम्पल शायद आप बाद में आएगा, लेकिन अब क्योंकि हम लोग ये डिस्कशन मैं बता रहा हूं तो आप ये भी सुन लो. The best example of this is Searchlight 1. And we again and again we are in these lectures today and tomorrow we are going to take a reference of Uttar Pradesh Legislative Assembly, as they have done all sort of a misuse of these privileges, possible misuse of privileges. In case of Searchlight 1 used to be a magazine, Blitz magazine here in Bombay. The editor wrote something about the Legislative Assembly of Uttar Pradesh. The speaker issued a notice of arrest of the editor of Blitz magazine. He was arrested in Maharashtra and was taken to Uttar Pradesh. And he was locked in one of the hotels in Lucknow, locked for 7 days. It definitely wasn't a jail. This is the first instance when the Supreme Court of India, for the first time in India's independent history, came across the issue pertaining to privilege and fundamental rights. Being a legislative assembly and a responsible position like speaker, knowing the fact that the speaker is in a position to adjudicate this matter, right? They should have brought this particular individual in front of speaker with immediate effect. However, the police was allowed to keep him locked in a hotel, right? The hotel doesn't exist today, but then the hotel, right, for 7 days. Can you imagine this? At least keeping him locked in a jail is understood to a certain extent. It is absolutely incorrect, no doubt. But then still keeping him in a jail is something that is still under the custody of police, wherein you can protect the life at least of a person. In a hotel, you can see that the person is at the mercy of, no one for that matter, right? Court did not inquire into question of privileges. You know what court did? Court said that this particular arrest is illegal on the account of Article 22 of the Constitution, right? And the person must be set free. Court did not inquire into question of privileges and question of freedom of speech and expression, right? At the first place, the matter is, why did this type of issue, or why this happened? पहला क्वेश्चन तो यह है कि ये हुआ क्यों? देखो, महाराष्ट्र में नहीं हुआ. The person was arrested by police. Whether legality of that arrest can be tested by court of law, वो हुआ भी बाद में. किसी होटल में नहीं रखा था वो, क्या नाम उसका, अर्नब को, है ना? So this is a very simple incidents that I would quote. So it is true that with privileges comes responsibility, but then to execute that responsibility, you need a responsible person. We unfortunately don't elect responsible, law-abiding people in the legislatures because we don't like to abide by law. That is a simple answer to that question. We don't like to abide by law, and so we elect those who would not abide by, those who would cross the law, violate the law, and favor us. That is our voting preference. And so we have all these types of legislators sitting in the legislature. Right. आगे चलते हैं. So as I said, Article 105 for Parliament of India provides these privileges, which we have borrowed from Section 71 of Government of India Act 1935. And same provision you can see sort of repeated in Article 194 of Indian Constitution. As you can see, the clauses here assures freedom of speech inside the legislature, and clause 2 explicitly protects the act of speaking and voting by members inside the legislature from judicial proceedings of any kind. Right? They have protection, freedom of speech and expression, and their freedom of speech and expression of the acts done by them in the House are not questionable in any court or a court of any kind. Of course, then clause 2 talks about publication of matters without permission of the Speaker of the House. Nothing can be published. Right? The House would only permit what is to be published and what is not to be published. Yeah, so we will only discuss this part, these two things, and then we have 10 minutes, so we can manage to discuss this. So much of the disputes have arisen from clause 3, which empowers Parliament to define its powers. 105 clause 3, which empowers Parliament to define its powers, privileges, and immunity in other respects. For ascertaining the existence of privileges, the original language of clause 3 stated that, original language of clause 3 stated that they shall be the same as those of the House of Commons of United Kingdom as on the coming into the force of the Constitution. Original language of clause 3 said that, है ना, जो मैंने थोड़ी देर पहले बताया आपको, 26 of January 1950 को हाउस ऑफ कॉमन्स के जो लोग हैं उनको जो प्रिविलेजेस है वही इंडियन लेजिस्लेटर्स को होंगे, इंडियन पार्लियामेंटेरियंस को होंगे. Right? This is original. This clause was amended in 78. Even though the explicit reference to the House of Commons was removed, what did we do? हमारे कॉन्स्टिट्यूशन में हाउस ऑफ कॉमन्स लिखा हुआ है ना, अच्छा ही लगा हमें, तो हमने सोचा निकाल देते इसको. एक्सप्लिसिट रेफरेंस टू हाउस ऑफ कॉमन्स वाज रिमूव्ड नाउ, है ना. जुडिशरी इज वेरी क्लियर. अब आपको पहली बात तो ये समझ लो, पहला स्टेटमेंट एक्सप्लिसिट रेफरेंस टू हाउस ऑफ कॉमन्स इज रिमूव्ड, इसका मतलब क्या हुआ? मतलब क्या हुआ? द स्टार्टिंग लाइन, जो रेफरेंस लाइन है ना, रेफरेंस लाइन, उसका जो प्रेजेंस था आपके कॉन्स्टिट्यूशन में उसको आपने निकाल दिया. मतलब अब आपके पास, यू कैन एज्यूम, बिकॉज इट इज नॉट इन द कॉन्स्टिट्यूशन, यू कैन एज्यूम दैट अब कोई रेफरेंस लाइन नहीं है ना. तो अब तो जो हम करे सो कायदा हो सकता है. आपको बात समझ में आ रही है? पार्लियामेंट कैन मेक लॉ डिफाइनिंग इट्स प्रिविलेजेस एंड ऑल, है ना. तो इसके लिए रेफरेंस लाइन क्या था? 26 जनवरी 1950 हाउस ऑफ कॉमन्स. हमने क्या किया, अमेंड करके हाउस ऑफ कॉमन्स ही निकाल दिया उधर से. हाउस ऑफ कॉमन्स निकाल दिया एक्सप्लिसिट रेफरेंस. तो अब तो आपके पास कोई रेफरेंस लाइन नहीं है ना, तो अब तो आप वो लॉ बना सकते हो प्रिविलेजेस को लिखने के लिए जो आप चाहे. कोर्ट हाउएवर इंटरप्रेटेड, कोर्ट्स इंटरप्रिटेशन हैज फेवर्ड द व्यू दैट लेजिस्लेटिव चेंबर्स इन इंडिया continue to enjoy the powers, privileges and immunities that were available to the former on 26 January 1950. कोर्ट ने क्या बोला? अच्छा, हाउस ऑफ कॉमन्स निकाल दिया ना आपने, इससे कोई फर्क नहीं पड़ता. कोर्ट ने इंटरप्रेट ये किया कि आज समझ लीजिए 2022 में पार्लियामेंट के जो मेंबर्स है इनके लिए कौन से प्रिविलेजेस है. अगर हाउस ऑफ कॉमन्स हमने वहां से निकाल दिया तो कोर्ट ने बोला नहीं, कोई दिक्कत नहीं. 26 जनवरी 1950 जो है उस वक्त जो चेंबर था हमारा, था क्या उसको कोई पार्लियामेंट? तो इंटरिम गवर्नमेंट एस्टेब्लिश किया हुआ है, जो कॉन्स्टिट्यूएंट असेंबली मेंबर्स थे वही दे कंटिन्यूड एज अ पार्लियामेंट. उनको जो प्रिविलेजेस थे उस वक्त, तब समझ लीजिए 27 जनवरी 1950 पे उनको जो थे वही आ. मतलब तो वही हुआ. मतलब कोर्ट ने क्या किया, इट ब्रॉट दैट पेंडुलम टू द सेम पोजीशन अगेन बाय इंटरप्रेटिंग दैट your formers had those privileges and only those privileges. So what is constitutional limit on your parliament's power to legislate? The limit has been set. Limit is basically that date and those privileges enjoyed by the former members of the same legislature. You can continue with the same. The question is, why should we continue with the same? The reason being they are based on conventions. So who went on to set the conventions? Those who were the first members to sit on these chairs. They set the convention, now you continue. Similar and simple interpretation. So this position enables the identification of implicit limits for their permissible use, subject to the inherent differences in the structure of the government contemplated by Indian Constitution. अब इतना भी सिंपल नहीं है. ये बात तो हो गई, हाँ ठीक है, तब जो थे वो आज हो गए, है ना? लेकिन आपको ये समझना पड़ेगा, जो तब थे वो इंग्लैंड से बोरो किए थे, है ना? जो आज है वो भी इंग्लैंड से बोरो किए हुए, लेकिन जो तब था वो इंग्लैंड का गवर्नमेंट था, आज आपका कॉन्स्टिट्यूशनल गवर्नमेंट है. हो सकता है कि कॉन्स्टिट्यूशनल रिप्रेजेंटेटिव डेमोक्रेसी जो आपके कंट्री में है वो शायद कुछ प्रिविलेजेस के एक्सरसाइज को लिमिटेशंस डाले, और ये हो भी सकता है कि आपका पार्लियामेंट खुद ही लॉ बना के कुछ नए प्रिविलेजेस लिस्ट डाउन भी करे. ये पॉसिबिलिटी इंग्लैंड में इमेजिन करना प्रिविलेजेस के लिए थोड़ी डिफिकल्ट है. क्यों? क्योंकि इंग्लैंड में प्रिविलेजेस बेसिकली कन्वेंशनली ही डेवलप हुए. हमारे यहाँ पे पार्लियामेंट अलग से लिख सकते हैं. बात समझिए आपको कुछ? एवरीबडी सब्जेक्ट टू द लिमिटेशंस ऑफ रिटन कॉन्स्टिट्यूशन ऐसे होना चाहिए. हम लोग बोल रहे हैं सब्जेक्ट टू द डिफरेंसेस, इनहेरेंट डिफरेंसेस इन द स्ट्रक्चर ऑफ गवर्नमेंट कंटेम्पलेटेड बाय द इंडियन कॉन्स्टिट्यूशन. वहां पे तो वो हमारा और उनका सेम नहीं है ना गवर्नमेंट, है तो वेस्टमिंस्टर मॉडल, कॉपी पेस्ट नहीं है, लेकिन कुछ अंतर है. तो जो अंतर है वो अंतर शायद कुछ डिफरेंसेस ला सकता है प्रिविलेजेस के एक्सरसाइज में. कळलं का काही? एक्सप्लिसिट रेफरेंस, हाँ exactly, in fact do both. So his question is, what was the intention behind removing this explicit mention of House of Commons? So writing new privileges is definitely one of the intentions, but then completely cutting us from any colonial identity directly in the constitution. The word House of Commons, है ना, it is to be avoided. क्योंकि ये कॉन्स्टिट्यूएंट असेंबली डिबेट में भी हुआ कि हम लोग क्यों बोरो करें, कॉपी पेस्ट करें. क्यों? मैंने बताया ना आपको, मौलाना हसरत मुहारी तो ये बोल गए कि आपने कुछ लिखा ही नहीं है, आपने बस जो इंग्लैंड में था और गवर्नमेंट ऑफ इंडिया एक्ट 1935 में जो लिखा गया, आपने बस वहां से कॉपी पेस्ट करके यहाँ पे चिपका. अगर आप असेंबली डिबेट पढ़ोगे, है ना, ये नवंबर 1948 में ये बात हो रही थी, तो उन्होंने बोला कि ये आपने कुछ नहीं, ये बस कॉपी पेस्ट किया हुआ. और तब बाकी अम्बेडकर ने, डॉक्टर अम्बेडकर डिड गिव एन आंसर टू इट. बट देन यस, एट द फर्स्ट प्लेस टू अवॉइड दैट एक्सप्लिसिट रेफरेंस. क्यों हम लोग ये बोले ना कि हम लोग हाउस ऑफ कॉमन्स को फॉलो कर रहे हैं एक्सप्लिसिटली कॉन्स्टिट्यूशन में, एक. और दूसरी चीज, अगर वो बैरियर, वो एक रेफरेंस लाइन निकाल दिया जाए, तो आपका पार्लियामेंट वो रेफरेंस लाइन के बियॉन्ड भी कुछ अब प्रिविलेजेस लिस्ट डाउन कर सकता है. ये दोनों चीजें करते का. वेरी गुड. So that is all for today. Scope, wait. Lecture खत्म नहीं किया. Scope of legislative privileges and its extent कितना होगा, कितना होना चाहिए, that we will discuss tomorrow along with those examples. One of the examples I have already talked about, Ritz method, है ना. Hopefully, I think tomorrow we'll complete this part. शायद कल हम लोग इसको complete, अरे आएगा तुम्हें, शायद कल हम लोग इसको complete करेंगे. There is going to be a test for you. Test. writing test. Few questions and then you will have to write the test, right? For which there will be separate discussion, most probably in the second